Okay. Hi everyone and welcome to today's webinar. Before we get going, can I just ask that everyone can hear me? You can let me know by typing yes in the question box on the right of your screen. Okay, great. I can see those coming through. Thanks for submitting those. So for those of you I haven't spoken to recently, I am James. I'm James Spann, your lead accountant. And my primary focus is to provide you with all the support and advice you need to effectively manage and get the most out of your business. I want to make sure that you're getting proactive, real-time advice and that any questions or concerns about your company are quickly resolved. So you're able to focus on what you do best, of course. One question I have been asked a lot about recently has been the upcoming changes to IR35 in the private sector. What's changing, how this might impact you in your role, and if there is anything you can do to increase your knowledge and get ready in time. Without spoiling too much of what's to come, I have asked our Compliance Director, Matt Fryer, and our Sales Director, Paul Lloyd, to talk to you for the next 40 minutes and provide you with an update on everything IR35, the options available to you, and what you can be doing to prepare. As some of you may know, Brookson have been supporting contractors with all manner of legislative changes since the implementation of IR35 in 2000. And we have a wealth of experience when it comes to supporting not only you, but recruiters and end hirers who had to navigate the 2017 public sector changes. And we're now supporting recruiters and end hirers with the changes coming into the private sector coming in April 2020. I hope over the next 40 minutes we're able to provide answers to your questions and reassure you that with Brookson you're in the best possible position to navigate through these changes. If you have any questions at any point, please submit them in the question box on the right of your screen. Matt and Paul will do their best to take as many of those as they can. Any they don't get round to answering, I will pick those up with you once the webinar has come to a close. I'll now pass over to Matt and Paul. Over to you guys.
Thank you and hello everybody. My name's Matt Fryer, Group Compliance Director at Brookson. Before we get into the detail of today's webinar, I just wanted to run through the quick agenda for you. So we're going to start off with a background to Brookson. Clearly you know that we are accountants for you guys, for limited company contractors, but we also just want to talk to you about some of the offerings we've got in the wider group, which helps to frame the when we talk about the support that we're giving to the contractor supply chain with regards to these changes. Then we'll look at the background to IR35, why does it exist, what it's intending to do, and ultimately why government think they need to change the rules. And then we'll move into preparing for April 2020. What are these changes that are going to be faced, and how do we think the supply chain should be preparing for them, and particularly things that you guys might want to think about doing in the run-up to April 2020. And then finally, we'll touch on how we can help you through these changes. So clearly, if you're not impacted by the rule changes, then you can continue to operate as you always have done through your limited company. If you do find yourself to be working on a contract that's impacted by these rules, there's other service offerings we've got within the Brookson Group that we can continue to help you with. So I'll now hand over to Paul.
Hi everyone, I'm Paul Lloyd, I'm the Group Sales Director for Brookson. So just to start us off, I want to talk to you a little bit around Brookson. So obviously you're already using our accountancy services, so you're probably aware of most of the services we offer already, but we've been providing services to the flexible workforce now for a long time, since 1995. And a part of the service that you use at the moment obviously is our accountancy service for contractors. We also offer an umbrella PAYE solution, which we'll take you through in some details later on. So, which is a great service there, is if unfortunately you're captured by IR35 by your end client in the future. Through Brookson Legal, we're able to offer legislative support to the entire supply chain. So for the previous kind of 18, 19 years, that's been offered to contractors. But now that the legislation's changing and it's your client that needs to make the determination for an IR35 purpose in the future, we're now already offering services up and down that whole supply chain to recruitment agencies and then hirers to be able to help them make the correct decision in terms of their IR35 status determinations. Additionally to that, we've also got Brookson Financial. We're offering specialist financial advice for contractors. So if you don't already take advantage of that, then a great opportunity for you to do some efficient tax planning. Across the bottom of the screen, you can see some of the accreditations there, and our accountancy and umbrella packages are accredited by FCSA. We also have the Brookson Legal, it's accredited by the Solicitors Regulation Authority, and Brookson Financial by the Financial Conduct Authority as well. So if you've got any questions on any of those, then please fire them across also.
So before we get into the detail around the changes, I think it's worth just looking backwards a little bit. What is IR35 and why is it here? And I think we need to remember that IR35 is a very specific piece of targeted anti-avoidance legislation. And it was originally introduced back in 2000, and it was designed specifically to stop an employee from resigning from their employment on a Friday and coming back on the Monday doing exactly the same job for the same employer, but they're now engaged through a limited company. And that was becoming more and more prevalent in the late 90s due to relatively high rates of pay-as-you-earn, specifically the employer's national insurance, and relatively low rates of corporation tax, and obviously there was no national insurance on dividends. So it was very tax efficient, not only for the individual, but also for the business that engaged the individual services to engage them through a personal service company. And there was nothing to deter that from happening until IR35 was introduced. I think it's important to remember that it's not designed to stop a genuinely self-employed contractor working through their own limited company. So this is anti-avoidance to stop what HMRC call disguised employees from attempting to avoid tax and national insurance. And really it's looking at, and we can see some of the key tests on the right-hand side of the slide. The test being, if you looked at the contracts in place, typically there'll be a contract between your limited company and your agency. There'll also be a contract between your agency and the end client. So you need to review the terms of those contracts. You'd also need to understand the working practices. So how does the business treat the contractor, and how does the contractor offer their services to the business? And once you've explored all of that, you put together a hypothetical contract. And the question is that one of employment or not? And the way you determine whether it's employed or not is by looking at employment case law that's been established over the last 40 or 50 years. And the three main tests you can see there are around control, personal service, and mutuality of obligation. So the important thing to remember is all three of those main tests have got to be present for it to be employment and therefore caught by IR35. If any one of those three tests is missing, it cannot be employment and therefore IR35 wouldn't apply. So it's really important when we're doing status assessments to concentrate on these three key tests. First one there you can see is around control. So the greater the control that the end client has over the contractor, the more it points towards an employment relationship. And the one that really is quite often the deciding factor is controlling how you do your job. So if you're a highly skilled specialist offering a project into a client who hasn't got internal resource, they're unlikely to be controlling or supervising you day to day in terms of what you do because you're the specialist. So that's a positive factor. If it's a relatively lower paid, lower skilled role where you're doing similar tasks as employees, where you have a line manager who's supervising what you do and telling you how to do it, that points towards a high degree of control, and therefore you might not have a strong argument on that particular test. So that's the control one. Second is exploring personal service. In an employment relationship, it would be the individual's name in the employment contract, and it would have to be that individual that turned up and did the work. They couldn't send someone else to do it. Typically in a contractor scenario, you would have the limited company would be the entity responsible for delivering the services, and you typically find a substitution clause in the contract that would allow that limited company to substitute various different contractors in to fulfill the contract. Now, and the key point on this one is if that clause is present, but crucially, if the end client would accept a substitute, without going through a significant amount of interviewing and checking, then that indicates that it doesn't have to be the personal services of that individual consultant. The more restrictions there are around the ability to substitute, the less argument there is that's a strong factor. So that's the second key test. The final one is this concept of mutuality of obligations. So in an employment relationship, there's ongoing obligations on both parties to provide work, do work, and pay for that work. In a self-employed relationship, there's typically, you would look for a defined deliverable within a defined timescale, and once that's been delivered, then both parties can part ways and there's no ongoing obligation to provide further work. So that's a real key area to explore, the point around mutuality of obligation. Interestingly, we'll come on later to look at HMRC's check employment status for tax tool. That doesn't include any significant questions on this point. HMRC are quite bullish that mutuality of obligations are present in all relationships, but when you look at the case law, that's quite often found not to be the case in an employment relationship. So they're the three tests that we would look at. They're the three tests that a court would look at when determining employment status. Now, there are other factors here in play, and it's always worth considering those. You can see those on the right. So things like financial risk. An employee doesn't take financial risk. A contractor might have to rectify defective work if they do something wrong. Are you in business in your own account? So have you got concurrent assignments? Have you got multiple clients? Do you look and feel like an employee? Or are you held out to be a consultant providing advisory firm services as a business? That's one thing to explore. Provision of equipment is another important factor. And there's a whole host of other points to look at. But crucially, you always need to get back to those three tests. And as I said earlier, if one of those isn't present, it can't be employed, and it's therefore safe from an IR35 perspective. So I find this slide particularly useful when we're out speaking to end clients, because their understanding of employment status isn't particularly well developed, and their natural reaction is they're concerned that a lot of their contractors fall inside of the rules. But once we talk about what the tests look like, quite often get them into a position where they feel comfortable that it's worth going through the process of properly assessing. And quite often they find that there's a higher percentage of people outside of IR35 than they originally thought. So that's IR35, that's the employment status test. Why are things changing? Why is it not currently working? If we look back to when the rules changed, HMRC did a risk assessment back in 1999, and they were expecting to raise around £300 million of additional tax and national insurance. Now, you can see from the slide here that a couple of years after it was introduced, they're actually only raising £9.2 million a year. So it's seen really as a policy failure, and it's been a policy failure for two reasons, I think. Reason one is HMRC just don't have the resource to police the number of personal service companies, personal service company being a limited company that provides the services of an individual contractor. The number of PSCs has continued to grow, mainly because there's a bit of a shift in the dynamic of the UK workforce. There's more people who want to work flexibly. There's more people who want to be self-employed, and more businesses, a term I use quite often, they want to use contractor services. They don't want to own the contractor. So there's a bit of a shift in the UK employment market towards growth in self-employment. Clearly, if that self-employed individual provides services through their own company, then we're seeing a growth in the number of personal service companies. Also, HMRC, have, as I mentioned earlier, just haven't got the resource to go and do an individual IR35 status assessment on 650,000 personal service companies. So they have struggled to police the existing rules. And that's meant that in some areas of the market, there's been exploitation and avoidance occurring. And that typically happens in the lower paid, lower skilled, sometimes vulnerable worker end of the market, where we are finding now that there are
individuals providing services through a limited company. They don't even know that they're a director of that company. And it's all being done to avoid employment rights, to avoid employers' national insurance, avoid pensions obligations. And that's where the real abuse is happening. And that's why HMRC and the Treasury have calculated around £1.3 billion of non-paid tax. That isn't as a result of genuinely self-employed individuals providing the services. But as ever with tax rules, it's a bit of a sledgehammer to crack a nut, and every PSC is potentially going to be impacted by these changes. So it's a little bit of a shame that we've got here, but HMRC and the Treasury feel they need to do something to stop that non-compliance, and it's obviously impacting the whole market, which is where we've got to now. Just interesting then to look back a little bit to 2017, where we saw changes similar to what we're going to see in April 2020 impact the public sector. Now that wasn't implemented particularly well, mainly because the changes came pretty quickly and the public sector didn't have time to prepare properly. There were lots of end hirers unprepared, which resulted them coming out with blanket bans, i.e. capturing every single worker within IR35, even though they hadn't done a proper assessment. That resulted in lots of contractors looking around the market for ways of enhancing their take-home pay, which resulted in a growth in non-compliant providers, particularly in the umbrella space, which introduced new risks in the supply chain, which HMRC are now clamping down on. There's also a growing concern actually amongst private sector hirers that if they find a contractor to be inside of IR35, does that mean they have to employ them? Does that mean they expose themselves to employment rights concerns? And I think those risks are they're real risks. And for us, that's the messaging to end clients that you need to take this seriously. You need to run a proper assessment for every individual contractor and not implement a blanket ban. There's a key thing in the legislation which we will have in the private sector as well, which asks the client to take reasonable care when making the assessment. And there was a bit of confusion around what that meant. We've got a bit more clarity now, and I'll touch on that in a later slide. And clearly a big issue for the public sector was, because a lot of organisations did the blanket ban, they lost a lot of their valuable contract resource, which wasn't great from a commercial and competitive perspective in terms of attraction and retention of contractors. So there's lots of things we can learn from the public sector change that we're using to educate private sector end hirers into, how they should be approaching this correctly, with a view of ensuring they are able to retain and continue to attract personal service companies and contractors. Okay, so what we're going to see in the public sector, we've got an implementation date now of the 6th of April 2020. So these changes will apply to any payments made from that date. So one takeaway would be to think about the payment cycle you currently have with your agency or your clients. And some agencies are already planning to accelerate payments on around the date change. This is just to make sure that any work that you do prior to April 20, if you can be paid for that into your limited company under the current rules, prior to 6th of April, it means they'll be paid as normal without deduction of tax. If any of those payments are late and run beyond the 6th of April, and the end client thinks that you are inside of IR35, you may find that there's tax deducted from the payment. So what is changing? Well, this is a change in responsibility and obligations, really. The way that you assess employment status, the way you assess IR35 isn't changing. So the issues we looked at on the previous slide around control, personal service, mutuality obligation, that's still the test. The only thing that's changing here is the obligation to do that test is moving from you as the contractor up to your end client. And the person responsible for deducting the correct amount of tax will be the business that pays your limited company. And typically that will be a recruitment agency. So end hirers need to make the IR35 decision. They need to produce a document called a status determination statement and give that to you, and also give that to the agency that has supplied you into them. And that status determination will include their output of what they think your employment status is for tax purposes. and it will need to give reasons as to why they have come to that conclusion. And that obviously needs to be provided to you before the 6th of April 2020. Conversations we're having with hirers, I suspect they will start to be issued in February, March time. So it's one thing to look out for in the new year. So that's the big major change there. There's changes around risk and liability flow in supply chains. And this is HMRC trying to ensure that if an end client has determined that someone is within IR35, that the correct amount of tax is paid. What they're trying to stop is businesses entering the supply chain who will pay contractors gross, essentially ignore the end client's decision. And if they're found to be, if they're investigated and found to owe additional taxes, that businesses will just liquidate and disappear. So again, the liability flow, which Paul will look at shortly, is intended to stop non-compliance in the supply chain. There is a hirer-led challenge process within the draft legislation, and this is a way of trying to address contractors' concerns that an end hirer may make a status decision and miss some of the relevant factors, or not do it properly, or make some sort of blanket decision. So there is a process by which you as the contractor can challenge the hirer's decision. And if you submit a challenge to that, they've got 45 days to respond to you. So again, that's something worth thinking about. If you get that status determination statement and you disagree with it, you are able to challenge to the hirer. The hirers will probably be looking for you to provide information and raise the specific reasons why you're challenging it. Another key point here, this reasonable care concept remains in the legislation, and HMRC are asking end hirers to take a reasonable care approach to the assessment around status. And essentially they're asking end hirers to do it properly. And if HMRC view that they haven't done it properly, then they could have some tax risk. So the hirer-led challenge process and the focus on reasonable care is HMRC's attempt to get private sector organisations to do this properly and ensure they come to the right answer. Final thing worth flagging here is there is a small company exemption. So if your client, and this is your client, not your agency, so the client who you're providing your services to, if they have got fewer than 50 employees, if their turnover is less than 10.2 million and their balance sheet value is less than 5.1 million, so any two of those three tests, they are defined as a small company and they're exempt from these changes. So that means you as the contractor will continue to have to manage your obligations. Now, there is a bit of debate at the moment around the 50 employees. If a business has got 49 employees and 5,000 contractors, does that mean that they're outside of the rules? And the debate is around if any of those 5,000 contractors are deemed to be inside of IR35, does that make them an employee for this test? So I think we're just waiting to get a bit more clarity around that one. But the reason I'm flagging that is you may not get a status determination from your client. If you don't get one, it's either because they haven't done anything, or it could be that they're a small company, in which case you continue to manage IR35 as you've always done yourself. So that's a brief overview of the changes that we are expecting in April 20. We've got the draft legislation, we're still awaiting the final legislation, but I'm not expecting any of that to change significantly. Brilliant, thanks, Matt. And some of the things that we're talking to end clients around and agencies around when we're seeing them now is some of the challenges that they face, and probably things that you as a contractor can help with is starting to have open conversations with your clients and recruitment agency about some of these. So the processes that your client will have to go through at the moment is they're going to have to assess their whole workforce and obviously take reasonable care within that. So some clients have maybe one or two contractors, some have 5, 6, 7 or 10,000. So that change process can vary dependent on the size of the hirer, and also vary dependent on how far they are through that process. They're going to have to communicate with the whole supply chain, which is something we'll come on to in the next slide in terms of the way that they need to communicate that status determination statement. And then they need to look at compliance within the supply chain again, because that liability flow that we're going to come on to on the next slide. And then one of the most difficult parts is how are they then going to deal with contractors who fall inside of IR35. So again, looking at the compliance from the supply chain and the payment vehicles that they're going to use to to be able to make that appealing for you to still to work as a contractor, and we come on to some of those a little bit later on within the slide. But they're all challenges that hopefully your client is looking at the moment. If they're already discussing this with you, then that's good. That means they're already on with it. Hopefully the conversations are already moving. If they're not, then we're also happy to help with that. And we'll talk a little bit later again around how we can possibly help some of your clients if they've not got started on this change process already. So taking a look at the liability flow that's been introduced or is going to be introduced within the private sector legislation. The reason for showing you this, I suppose, is twofold. One is that the status determination statement needs to be passed down the supply chain. So in this diagram, it's quite a long supply chain. So it would need to be passed from the client to intermediary 1, to number 2, to number 3. And in this example, number 3 hasn't passed that status determination down, so they would carry that tax risk there. So anyone not fulfilling their obligations within the supply chain will carry any liability that might arise from that. The client also needs to communicate with you as your limited company or personal services company. And as Matt mentioned before, that status determination statement needs to include the determination of whether you're inside or outside of IR35 for that role, and also the reasons. That will allow you to be able to look at the reasons, how they've come to that decision, and then possibly raise a challenge process if you need to do that. The second part of the liability flow is that there's an upwards liability flow. So in the instance where intermediary 3 hasn't fulfilled their obligations in this diagram, if HMRC come to collect any liability there and intermediary 3 no longer exist or are unable to pay, the HMRC have the power to be able to move back up the supply chain to intermediary 1 and the client. Now, I suppose the important part for you here is this may result in the person that's paying you, likely to be your agency, asking questions around who you're getting paid through, or what payroll vehicle you're using. So any non-compliance in that supply chain can create risk all the way up and down it. So it's important to be aware that you may get asked some questions on that. Nothing really to worry about, just making sure that you're using a compliant payroll vehicle in future there more than anything.
Yeah, so just touching on reasonable care, this is a really important point when we are speaking to clients. If we think back to why HMRC are changing the rules here, they're changing them because they just haven't got the resource to spend, and sometimes it can take 2, 3, 4 years to do an individual IR35 inquiry on an individual contractor. So what HMRC want to do is police this at end hirer level, not at contractor level, because there's fewer end hirers. Also, they don't want to have to police this by getting into the detail around every single individual status for IR35 purposes. They want to be able to assess whether the client's approach to managing the change is reasonable. Have they taken reasonable care? And reasonable care is yet to be, it's not defined in the legislation. We have yet to see any published guidance from HMRC on what it means, but there is some draft guidance that we've been asked by HMRC to review around what reasonable care looks like, and it basically is asking a business to do this correctly and spend adequate time and resource considering it. So it does say point 1 on reasonable care is if they've used a professionally qualified expert to come in externally and review their workforce and give them an IR35 view, that's reasonable care. If they've just asked their HR department, who have got no knowledge of IR35, to come up with an employment status decision without having any adequate training, that doesn't demonstrate reasonable care. If they've taken a blanket ban, and that's where they say all of our contractors are inside of IR35, we haven't really looked at why, we're just saying you're inside, that doesn't demonstrate reasonable care. So we will expect that guidance to be published shortly. And really it's pushing end clients to do this properly and make sure they spend the time considering the IR35 status of every single role that they have got. A key point here is HMRC have tried to help end hirers meet this obligation by producing an online tool, the Check Employment Status for Tax, or the CESS tool. Now, I mentioned earlier that the current version, which has recently been updated, it doesn't consider one of the key employment status tests around mutuality of obligation. We are also finding that around 20% of all the scenarios you run through that tool come out with a
a status of can't be determined. So that there's a growing feeling within the market that if it went to a tribunal, that CEST doesn't count as reasonable care, which is a bit of a shame. I think it was a good idea for HMRC to try and produce a tool to help clients. It's just not there yet. So we're going to see an update of that one. I think it will be further updated as we go. So I think the other thing around reasonable care in the draft guidance is it says that if an end client receives an employment status determination from the contractor themselves and hasn't double checked to make sure that that decision is aligned with their own business's view, that doesn't count as reasonable care. And I think that's a key point here, certainly in our approach to this. This is making sure that end hirers are making the assessment and passing it down the supply chain. This is not going to be contractors making an assessment based on what they think is the correct information and giving that to the client. So this is very much a client-led approach, hence our repositioning of Brookson Legal to engage with and help as many end clients out there as we can get round to make sure that they come to the correct decision. Yeah, and a couple of extra points on CEST from me there as well. I suppose one of the key points is that it's based on HMRC's understanding of case law, and Matt mentioned before that their view on mutuality of obligation is different and have been proven wrong a considerable amount of times in case law. They've also been challenging their own tool and the decision that it's come to recently, which is quite, I suppose, concerning. And there's currently the new version of the online tool has almost a disclaimer on the front page as well. In a couple of cases, there's been a recent tribunal, HMRC versus Ralph, where they tried to have the results of CEST excluded from the tribunal. They were unsuccessful in that, and the results of CEST were included. HMRC lost the case, and predominantly again on mutuality of obligation. And then most recently, there's been NHS Digital have made a provision for quite a large fine, around £4.5 million in their accounts, and they were seen to be using CEST to make the determinations for the first couple of years since the public sector changes came in since 2017. So I think there's quite a lot of problems, and CEST is very heavily criticised. Like Matt said, it's a shame that doesn't work. I think that, again, the key difference between someone like ourselves, that where we can offer proactive advice on that kind of 20% where CEST can't make a decision, is probably where Brookson Legal or a law firm really comes into their own to be able to give proactive advice on how those working practices can be amended. And we'll talk about that a little bit later when we talk about how we're helping some clients as well. Okay, so taking a few bits of recent case law, these are some quite high profile cases, obviously more within the kind of media sector. But I suppose the idea behind this is really to talk to you around what Matt spoke about earlier, is that you're looking to prove that you're not employed, so where some of those cases where some of that case law doesn't apply, and again, looking at not having to pass all the tests there. So if you take the middle one for Paul Hawksby, obviously the tribunal that he went to decided that he couldn't provide a substitute, but was okay in terms of in business in his own right and control and mutuality of obligation. The Lorraine Kelly case, for example, has since been run through the CEST tool, and the CEST come back as that she should have been inside of IR35, and that was HMRC's view, and that's why they took her to tribunal. However, obviously, at appeal, she was fine in terms of the court decided that she was outside of IR35. So getting correct advice, I suppose, is the message for this, in terms of making sure that you're getting the correct advice on your working practices and making sure that the client understands that at the moment, obviously, it's your determination, but actually within the next few months, it's the client's decision. Sometimes they're quite poorly educated in terms of those working practices and how they should be engaging with workers. So again, something that we've been doing is highlighting how important it is to make sure that you've got your working practices and your engagement model right with your contractors, and also talking to clients around how they can change those working practices legitimately as well. A little bit on take-home pay difference. So obviously this is going to be something that will be of interest to you. If you visit the brookson1.co.uk website, there's like a slidey bar in terms of a take-home pay calculator, so you can get some more bespoke examples to your own hourly rate. But if we take an example there in terms of Lucy, so £50 an hour, approximately £400 a day, through an umbrella PAYE scheme, likely to be taking home probably just over £1,100 per week, after tax and national insurance has been deducted. However, through a limited company, we'll be looking at more like a take-home pay of, or being able to withdraw just under £1,600 per week. Average sort of take-home pay difference is approximately 20%. But as I said, if you visit our website, then you should be able to get some more clarity on that. Or if you do want to get some more bespoke illustrations based on your personal circumstances, then we can do that for you over the phone. But I think using the website until you understand what your working practices are going to be moving forward is probably the most important part there. And then a little bit later on, we'll talk through some different working options for you. So obviously, either the inside and outside options in terms of what's on the screen for you for umbrella, PAYE or limited company. And then we've also got a range of solutions that may be helpful for you as the changes come into effect next year.
Yeah, and I guess just positioning on this slide, we obviously the limited company number there is the amount that you're currently earning through your PSC outside of IR35. We expect the vast majority of our clients to remain able to do that and be outside of IR35. That's just on the basis that the clients do everything that they need to do and hit that reasonable care threshold. I think the reason for this slide is just giving you a bit of an insight into if the client determines that your role is inside of IR35, that umbrella pay as you earn is likely to be reflective of what your net pay might look like as a result of that decision. Hence why it's important for you to think about, does the agency you're working for and the client that you're working at know what's coming, know what's around the corner, know what they need to do. And this is all about preservation of that limited company rate. If they make a hash of this and inadvertently treat you as inside of IR35, you could see that differential in take-home pay.
Brilliant, thanks, Matt. And something else that we would normally start to talk clients through are some working options that are on the screen in front of you. So if you're on the left-hand side of the screen and you fall outside of IR35, then there's no need for any change to the way that you work. You can continue to work through your limited company. For anyone that is deemed inside of IR35 by their client, there's a range of options available to them, dependent on how they want to engage contractors in the future. So starting from something like the deemed PSC, where you're going to get paid net of deductions into your limited company, you're able to withdraw all of that money, no corporation tax is due. So it is a valid way of working, but obviously that's going to only be applicable in certain circumstances for you. If they look to put you onto the client's payroll, then they need to offer you employee benefits and probably uplift the rate by the employer's NI, or they're going to be liable for the employer's NI. What we saw in the public sector was that there was a range of these solutions offered by clients in terms of where they may look to increase the rate by a certain percent to be able to compensate. And I suppose the important part of this slide is that what we try and do is talk clients through in terms of what's their risk of losing contractors is, because the contractor workforce is really important to clients in terms of the flexibility that allows them, and also to be able to source good quality candidates with unique skills that aren't available through their full-time employees. So that kind of talent turnover risk bar in terms of the red exclamation marks near the bottom is what we'd normally talk to them about in terms of if you look to offer no rate increase or have to put or you take a blanket PAYE approach, then you're very much more likely to lose the contractors that you need to complete these projects, and are going to cause delays for you. So trying to talk to them around the amendment of their working practice and the flexibility in their approach to working with contractors allows them to be able to make sure they can still acquire the best talent in the marketplace as well. So some of the working options that we have currently, and I've also created to be able to offer you more flexibility again, is that again if you're outside of IR35, no change in terms of how you want to continue working now or in the future. If you're inside of IR35, it depends on, I suppose, on your future intentions in terms of contracting. So I mentioned before that the deemed payroll, so that's where the person paying you would deduct tax and national insurance before paying your limited company bank account, and that would be net of any deductions. Corporation tax doesn't apply, and the only thing you'd need to pay out of there is any relevant accountancy fees and possible insurance fees if you've got those. If you're going to be, I suppose, captured or inside of IR35 for your next assignment, and that's maybe a 3 or 6 month assignment, then we offer where we can put your accountancy service into non-trade or dormancy and offer to put you through our umbrella solution, so the outsourced employment business. We have a new service called Brookson Flex, where we're able to give you the flexibility to be able to work through your limited company or your umbrella solution just for the one cost. So effectively, if you're with us for your accountancy and you need to use our umbrella solution, then we can waive the umbrella margin. And if you're paying your accountancy fee. So it gives you a little bit more flexibility and ability there. And I suppose that the main benefit here is because you currently are a client of Brookson, we're able to offer you a range of services to suit you, dependent on the flexibility that you need for changes that come next year. If you're going to be permanently captured in terms of your role, so if you think that you're not going to get future assignments that are outside of IR35, then looking to close your limited company down the most tax efficient way and transition into an umbrella PAYE role might be right for you. But if you're going to have roles that are outside of IR35 in the future, or you're hoping to change assignments, then you should be looking at kind of one of those three options in terms of the deemed, the non-trading umbrella, or the Brookson Flex product, where we're able to offer you a little bit more flexibility in the way of working. We have some contractors that have multiple assignments, where you might have 3 days for one client and 2 days for another, where you might have different status determinations for both. And again, those flexibility of products will allow you to work through that, and that's something that we can give you some advice on. If you do get to the point where you need to close your limited company down, then again, that's something we can look to give you advice on in terms of how you go about doing that. And dependent on what funds you have in your bank account, will depend on which process you go down. If you've been contracting for a long time, most tax efficient way, more than likely, is to go through an MVL, or member voluntary liquidation, and we can give some advice and pass you across to some companies in terms of the details for that. But again, if you need more information on these services, then we'll be able to give you a little bit of advice around that. And there's information also on our website around we can do that. I think that the most important part here is that there's no need to do anything just yet, and I suppose just to understand that we have a range of solutions that allows you to work in whichever way you need to work next year. Okay, so case study on the screen now. A couple of case studies there just to talk to you around the what we're doing currently. So for the last 9 or 12 months now, at least, and probably a little bit more since the changes in the private sector were announced back in the autumn statement of 2018, is we've been talking to the recruitment agencies that we currently work with, which is about 1,000 recruitment agencies that we currently partner with, around how we can help them understand the change and start to prepare for the changes. And then through those recruitment agencies, we've then been meeting clients, so meeting the end hirers that you're providing your services to and starting to give them advice. And now over the last 2 or 3 months, some of those hirers have started to engage with Brookson Legal to do the reviews for them, so to outsource the obligations that they've got and make sure that their reviews are done efficiently. A couple of examples on the screen around how we've gone through that is that we've been able to do the reviews for those clients, and the way that we do that is on a RAG status, or a red, amber, green status. So we would look at all their contractors, and the reds would clearly be inside of IR35, where the greens would be clearly outside of IR35. The ambers are normally where there's things that need amending legitimately within their working practices, and that's where we're able to add real value to those clients. So where something like the CES tool wouldn't be able to give that proactive advice, that's where we can really, I suppose, come to the fore and offer proactive advice around how the client can change the way that they engage with contractors, can they amend their working practices, and really start to talk to them around how we can help them with that. And then obviously we provide them with documented information on the information that we've given them around their IR35 status assessment in case of any future audits as well. So this is a little bit more detail around how we help at the moment. So the first stage really is education, which is done through a range of mediums. So we can do that through webinars like this, through face-to-face sessions. Our team are out on the road virtually every day speaking to agencies, clients and contractors around the country, making sure that we're starting to educate people that use flexible workers at the moment. The main aim for us is making sure that people can prepare for the change next year, take reasonable care in their assessment, and that the legislation is implemented in the best way possible with the least impact possible on the flexible workforce. We clearly want to be able to help our contractors, and that's why we're running these range of webinars as well, to be able to give some advice and guidance. If at the moment, if you're getting your clients are speaking to you around IR35, or you're concerned that they're not doing anything at the moment, then we're happy to run these education sessions with them. We can do them via phone, kind of webinar, or face-to-face, and we're happy to be able to give that advice to them. It's completely free of charge, so please feel free to make the introduction, and I'd be happy to speak to them for you. If they then decide to go down the process of us doing the audit for them, then 2, 3 and 4 are the types of services that we can offer to them. So we'll help them start to understand the challenge, we'll make sure that we can start to assess the flexible worker population that they've got, which can be quite a big part, and then help them be able to establish their way of recruiting in the future. So making sure that they can give those status determination statements up front. So I think there's a lot of services that we can offer to the supply chain there, and it was, I suppose, one point of the webinar was to kind of explain that flexibility that we can offer to you and to the whole supply chain.
So I guess that's bringing us to the end of the webinar. We've got lots of questions coming in. I don't think we're going to have time to answer them all, but we'll pick a few to focus on. But I just think in conclusion, as Paul has said there, there's obviously lots that Brookson are doing in the background that you might not be seeing. And our sort of aim over the last 12 months and going forward is we know that IR35 decision and responsibility is shifting away from you, our customers, and is moving to end hirers. So we're investing a lot of time and effort to make sure that those end hires don't make the blanket decisions and they come to the right decision around contractors being outside of IR35 where that is the case. So we'll continue to do that, and you know, fingers crossed in the run up to April 2020 that clients do take a rational and measured approach to this, and we don't see more of the knee-jerk reaction blanket decisions.
Okay, so a few questions that we're going to try and pick out now. If we don't manage to get through your question, there are some contact details on there for your lead accountant as well. And we'll also try and make sure that we collate all the questions and put together a comprehensive kind of FAQ document. So I'm just going to pick out some of the key ones that we've received, and there is quite a few, so sorry if we don't get to your question. So one of the questions that come in is, what should I be doing now?
Yeah, so I think contractors might think, you know, I should be doing something, I should be proactive, how can I prepare? And I think at the moment our view is it's sort of BAU for you guys. Clearly, anything you can do to try and influence your end hirer to get ahead of the game. Lots of them are now mobilised, starting to do the assessments. I think the sooner that they can do the assessment and let you know what that output is, the sooner you know how you're going to operate going forward, and the sooner you'll know whether it's something that you wish to challenge. So I think it is still, you know, question the end client, maybe via your agency as well. The sooner you know, the sooner we know what they're planning on doing, the sooner you'll know what you want to do moving forward, and the sooner we can advise you around what solutions would work best for you.
Okay, thank you, Matt. Then the next question is there any retrospective risk of HMRC targeting individuals? So that's a really good question. They get asked quite regularly, actually. So, Matt?
Yeah, so I guess the main concern here is if you're a contractor who's been working outside of IR35 and your client determines that role is inside of IR35, what happens? Is there a retrospective tax risk for you? Now, HMRC have said they're not using this legislation change to target contractors in that scenario. They're going to enforce the new rules going forward from the 6th of April 20. And they sort of said that their resource will be dedicated to making sure that end hirers comply. Now, technically HMRC can look back up to 6 years on an individual's tax affairs. So if you're in a role that the client deems to be inside of IR35, my advice would be to make sure that you contract under a new contract. So you'd look to end the current contract that you're working on, the one that you believe is outside of IR35, and then enter into a new contract from April 2020 with the client going forward. And that just means you've got a clean edge and the client's applying the new rules to the new contract, and you quite rightly have applied the old rules to the old contract.
Brilliant, thanks, Matt. So do the rules apply if working outside of the UK?
Yeah, that's an interesting question, and we've been asking HMRC for more guidance around this. And as far as I can see, the rules apply based on, essentially it's based on the individual contractor's tax residency status. So if you're a resident in the UK, it could be in scope of the new rules. Now, the second thing that needs to happen is the client or the agency, or some of that payment or supply chain needs to be based in the UK. So I think the furthest I've got with this one is if you are UK tax resident, you may be working outside of the UK, but if payment comes through a UK agency, or you're seconded to work overseas by a UK client, then it's likely that these rules will apply. If you're working outside of the UK long term and you've broken your UK residency, and the end client and agency are outside of the UK, then the rules won't apply.
Brilliant, thank you very much. Again, another common question that's coming through is, do we think this will happen? Obviously, it's due for implementation in April next year, but there's quite a lot of change going on in terms of government and bits and pieces at the moment. So do we think this will happen?
Yeah, so I think it will. I think we're too far down the line now. We've got draft legislation. HMRC have recently updated the CES tool. There's updated guidance out there. So certainly HMRC and Treasury are pushing forward with the view that this is going to happen in April 20. We're starting to see some of the political parties say that if they come into power, they'll review it. The cynic in me thinks that's a bit of a land grab for votes from contractors. I think we'll always get back to Treasury waving the bit of paper that says there's £1.3 billion of tax at stake here, we need to do it. So I certainly think this will happen in April 20. I know the CBI are lobbying hard in the background, and they seem to have changed their lobbying from a further delay more towards a soft landing, which I think would be a reasonable approach to take. So this will be implemented in April 20, but maybe the first 12 months HMRC will say we won't penalise any businesses that get it wrong, but we'll carry out further education.
Okay, I think probably the last one for this, we're going to run out of time otherwise, is what are you hearing about blanket bans in the private sector, and are they lawful?
Yeah, so I think on the face of it, a blanket decision around IR35 status clearly doesn't tick the reasonable care box. So there's an argument to say that's unlawful. Would HMRC be bothered? Probably not, because they're getting the tax that they want to get. I think businesses making a blanket decision where they say you're inside of IR35, you can still work through a personal service company and we'll pay you net of pay as you earn into that company. I think they run a significant risk of obviously their challenge process being inundated with contractors challenging that decision. So what we are seeing, I think, is some businesses who are either not up for the challenge or have got too many contractors to even consider doing a proper review on all of them in the timescale. We'll start to see some businesses say we will ban the use of personal service companies in our supply chains, and some of the big banks are doing this. So by doing that, they're essentially terminating contracts with personal service companies and engaging through different methods, typically umbrella companies or agency payroll. Now, if they're doing that, that means they're outside of these new rules because there's no personal service company in the supply chain. I think those businesses are taking quite a significant commercial risk, and I suspect there'll be a bit of a reset in the market over the next 6 to 12 months where they'll start to engage contractors again through PSCs. But I think they've just got a big challenge ahead of them in the run up to April 20, and then hopefully it'll revert back to more business as usual in the interim period.
Yeah, and that's definitely right, and definitely something we saw within the public sector as well, that maybe a bit of a knee-jerk reaction from some large entities early on, with a much more of a softening after that. I think that's all we've got time for today, but we're going to run over on time in terms of the webinar. So thank you very much, everyone, for attending. If you've got any further questions, please then send them into the details on the screen in front of you, to your lead accountant, and also we'll collate all the FAQs from all the webinars we're running and be able to build out a document on that in terms of all the questions as well. So thank you again for your time.
Thank you.